stay on. But I'm Eric Angel, Executive Director of Legal Aid, and this is such a hard time for all of us. And I think for the country and for the world, and certainly for DC. And so any opportunity we have in which we can sort of talk about local access to justice and poverty law issues is one that we want to take advantage of. And so since we decided to then set up this webinar series, make it sort of content and we realize, I guess we don't know who all you folks are, but I assume many of you are associates or summer associates at local DC law firms. I guess in the chat box, you guys could fill in and give us a little bit of sense who you are. And I'm going to turn it over. I know we have 3 great speakers today. Chin Lei, who is Legal Aid's legal director. Do you want to quickly say hi, Chin?
Hi, everyone. My name is Chin Lei. I am at Legal Aid. I've been at Legal Aid for about 9 years, and it's been a really exciting 9 years and enjoyable 9 years. And I'm excited to talk to you all about one aspect of our work, and especially our partnership specifically with Dan Jarko, who's also one of our speakers today.
Jennifer Measy is one of our deputy legal directors. So Jennifer, do you want to quickly introduce yourself?
Sure. I'm Jennifer Measy, and I have been at Legal Aid for about 15.5 years. Before I was a deputy legal director, I was the supervisor of our public benefits unit, which handles matters related to SNAP or food stamps, which is what we're going to be talking about today. Thanks.
And Jennifer is probably DC's foremost public benefits poverty legal services expert, and we're lucky to have her. And Dan Jarko is former president of Legal Aid's board. Do you want to introduce yourself quick?
Sure, happy to talk to everybody today. I'm a litigation department partner at the DC office of Alston and Bird. I've been doing work with Legal Aid for a very long time. I've been on the board for about 16 years, and even before that, I did some pro bono work with Legal Aid, which I've also continued to do during my time on the board, and that's what we're going to talk about today.
Wonderful. Well, since I was obviously not even supposed to be here today, I will try to stop talking and turn it over to who wants to raise their finger? Jennifer. And I will maybe just stay out for a few minutes, but just the one other thing I just want to quickly impart is just how appreciative we are of folks from the law firm community. Yeah, if you identify yourselves, we'd really appreciate that. Folks from the law firm community who are showing such solidarity, at least thus far, I've really been experiencing it with the poverty legal services community. It is one of the special aspects of being in DC is I think our local law firm community is really all in its support of the access to justice movement and civil legal services. So to the extent all of you are likely at firms which have those connections with Legal Aid, just quasi thanks in advance. But Jennifer, I will promise to stop talking.
No problem. Yeah, so if people want to keep putting their information in the chat, that would be great. And this is our agenda for the discussion. I'm going to talk about the public benefits unit at Legal Aid and the importance of SNAP to our client community. Introduce you to the wonderful world of ABODs, because all of public benefits is acronyms, so this is one of them. And then turn it over to Chin to talk about what's involved in bringing the kind of systemic impact case in the public interest that we're going to be talking about. And then turning it over to Dan to talk about specifically this case and how law firms think about staffing these types of cases, as well as him personally. I think I speak for me and Chin and Eric in just acknowledging Dan's incredible contributions to Legal Aid, and he is one of our go-to guys for pro bono assistance and has just been a tremendous partner in everything we've done with him. So All right, so, and then the final administrative thing is just, we really would love this to be interactive. So if people do have questions, you can just put them in the chat, and Caroline Fair, who's one of our attorneys, is gonna monitor the chat. And if there's a question, we'll jump in, or we'll save those for when we're transitioning speakers. So with that, why don't we turn to the first section, public benefits and the importance of SNAP. So Legal Aid's public benefits unit represents people who have had denials of applications for public benefits, terminations, or reductions in those benefits. And the benefits that we handle include SNAP or food stamps, TANF or temporary assistance for needy families, sometimes just known as welfare, Social Security benefits, both disability and retirement, and then assorted healthcare, health insurance benefits. So Medicaid, Medicare, and the DC Alliance, which is a safety net program for immigrants who don't qualify for Medicaid because of their immigration status. So next slide, please. Oh, sorry, no, sorry, stay on that side, back to the other one. So SNAP, let me tell you about SNAP. SNAP was, it used to be called food stamps when it was started, and literally you would get stamps that you would turn in at the grocery store for food. But then as we moved to ATMs and electronic benefit transfer cards or EBT cards, it moved away from the stamps and towards something where clients could pay for their purchases with food stamps and have some more dignity, so that people didn't know whether they were using a credit card or using an EBT card from looking at them. So I'm going to just call it SNAP, even though it was food stamps for a long time. It was created in 1964 during the Great Society. And the purpose of creating SNAP was to safeguard the health and well-being of the nation's population by raising the levels of nutrition among low-income households. And SNAP is aimed at very low-income families and individuals. In the district, we've expanded the income eligibility threshold a little bit. So it will provide benefits, sometimes very small benefits, because benefits go up with the less income, the less income that a household has. And so in the district, you can qualify for some amount of SNAP benefits if you are a household of one with about $22,082 a month in income. And for a mom and 2 kids, a household of 3, you would be able to qualify with income up to $3,555. And again, at the upper income levels, you may only be getting about $30 or something, but it still is a helpful benefit for families who really have to, who come very close to not being able to provide for themselves and their households. The benefits you get from SNAP are not as high as we would like them to be. So if you're a household of 1 with no other income, you get $194 a month. And for that mom and 2 kids with no income, it would be $509 a month. And most households, about 80% of them spend all of their SNAP benefits in about the mid portion of the month. So you get your benefits June 1st, you would have spent them all by June 15th for many families. But that said, SNAP still does have an impact. It's counter-cyclical, so during recessions or depressions, as we may be in, the amount of benefits that people get goes up as their income goes down, and caseloads can rise to meet the new demands for food. It combats food insecurity. So food insecurity is just not knowing that you're going to be able to feed yourself and your family. And it helps lift millions of families out of poverty. Okay, so now the next slide. So I promised you I would explain what an ABOD is. ABODs are are able-bodied adults without dependents. So what that means is it's an individual between the ages of 18 and 49 who is physically or mentally fit to work, which is a slightly problematic definition, but that's what it is. So it's a lot lower than the, it's not the same thing as the Social Security disability standard, and lives in a household without any children or other dependents. So in 1996, when Congress was imposing work requirements on a lot of different programs, particularly on TANF welfare programs, they also created a work requirement for ABODs. And they imposed a time limit for people to meet that work requirement. So what that means is that if you are an ABOD and you're not working 20 hours a week or participating in some sort of approved training program, you can only receive SNAP benefits for every 3 months out of 36 months. So that means that there will be almost 3 years when you will not be able to get SNAP benefits if you are not working. But in recognition of the fact that it was kind of unfair to cut people off of SNAP if they couldn't work because there weren't jobs available, the statute built in a waiver process where a state could request a waiver of that time limit if there was a lack of sufficient jobs in that jurisdiction, and states could define those jurisdictions. So now we fast forward to the present, and the Trump administration proposed regulations that would have dramatically limited the ability of states to obtain these waivers by essentially restricting the ability of states to prove a lack of sufficient jobs. And I think Dan's going to talk about what the rule was and what our legal theory was. So this rule was promulgated. The U.S. Department of Agriculture, who promulgated the rule, received hundreds of thousands of comments, most of which opposed the rule. And Legal Aid also submitted those comments. And the reason we opposed it was primarily that this would be a very harmful policy, that states were in a position to figure out if there was a lack of sufficient jobs. And if there was a lack of sufficient jobs, you would have a lot of people who wouldn't be able to work through no fault of their own and wouldn't be able to get SNAP benefits, which would leave a lot of devastation. And so I will finish up with just a few statistics about who ABODs are and why this rule would have been so harmful. So the SNAP population as a whole, almost more than half of that population has a high school degree or equivalent. For ABODs, it's only 24%. A significant number of ABODs have histories of incarceration. They also tend to be disproportionately members of minority groups, African Americans, Latinx individuals who face racial discrimination in housing, employment, and all other aspects of our systems. They also tend to work in unstable occupations, so they may be able to get employment, but they won't be able to sustain it, which would mean they would sort of cycle on and off of SNAP, which isn't really good for anybody. And then finally, they also are more likely to have physical and mental health impairments that are not significant enough to get them disability benefits, and may be hard to document, but still would prevent them from working. So I'm going to turn it over to, if we could go to the next slide, please. Okay, so I'm going to turn it over to Chin to talk about what we did at Legal Aid to get ready for this case, and then we'll have Dan talk about the law firm involvement as well as the theory of this particular case, which Dan developed. Thanks.
Hi, guys. Before I get into the meat of it, I just wanted to give you an opportunity to participate, at least through the chat. If you have questions on what you just heard Jennifer talk about, please go ahead and type it in. I know that's a lot of information to cover in a very short amount of time. So we want to, have you come out of this with some better sense of not just the broader issues, but, more specifically, a good understanding of the SNAP program and the challenges that our clients are facing in light of the possibility of this rule change. I also wanted to let you guys know that if this were an in-person workshop or conversation, you'd benefit from Jennifer's awesome facilitation style, which is to encourage participation by throwing candy at people who ask questions or who answer questions. And unfortunately, we don't have candy. We can't throw it at you virtually. But I will find a way to acknowledge you if you want to participate. And we really encourage you to do that through the chat and later through talking as well. So even as I'm starting to talk about some of the considerations in putting together a systemic public interest case, I'd love to hear you guys throw out ideas in the chat box about what you think are considerations that ought to be taken into account as an organization or a lawyer or a community group puts together a systemic public interest case. I'm sure a lot of what I'm going to say is the kind of stuff that you probably are already thinking about in your own minds. And in just a few minutes, I'm only going to be able to cover a few things. So if you guys throw out ideas, we could even, kind of group think this a little bit more. I'm going to start with a couple of things. And the first that is a very legal aid focused thing about trying to develop a systemic litigation is the fact that we try very hard to have litigation drawn from the experiences of our clients, even systemic litigation. So we are talking today about the ABOD case in particular, but I could give you other examples of cases we've worked with Dan on and we've worked with others on. Some of them are directly the result of cases coming in through the door on a regular basis that bring a common fact pattern that make us think, you know what, we can respond to this through individual defensive cases, or we could find a systemic way to address the structural problem. And so in another case involving food stamps, for instance, we kept seeing that the DC agency that processes food stamp applications and recertifications was doing so in a way that was not timely, that didn't comply with federal timeliness requirements. And so as a result, Legal Aid partnered with other organizations and a law firm to bring a class action lawsuit to challenge the agency's methods and get it to comply with those federal standards. And all of that was drawn from the experiences of our clients. Even in a matter like this, where it is an issue of a new regulation about to go into effect, our reaction to it and effort to do something about it comes from our experiences working with ABODs, understanding the challenges that certain individuals have to find employment and how difficult it is to work even within the existing structures, given the fact that that DC has a waiver. And so the idea that this waiver might go into effect, we could speak from the experiences of our clients, saying how much of a burden, how much of a real harm it would be on our client community. So that's the first point I want to make. The second thing that I think is a serious consideration is sometimes something is really terrible policy, but in order to bring an effective claim, you really have to do good legal research to figure out how do you challenge that policy. There are plenty of things in this world where Legal Aid disagrees with a policy decision, but the solution is not to challenge it through litigation. We also have a policy advocacy component to our work, and sometimes changing policy means going to the DC Council, going to an agency and submitting comments on rules, finding other ways to try to make change. But in order to bring a good systemic lawsuit, you have to have a colorable claim, and that does require us to do a good amount of legal research to make sure that the lawsuit we are bringing is likely to succeed, or at least we have claims strong enough to bring and get the agency or defendant to the table to talk about a change. Dan is on the workshop with us today, and you're going to hear from him. But another key component and consideration is identifying a good partner or partners when necessary. Legal aid has brought a number of systemic actions, lawsuits, even class actions on our own. But oftentimes, given our resources and our focus on individual representation, systemic litigation is a component of our work, but it is not the overwhelming majority of our work. So we do need to make sure that we continue to dedicate resources to individual representation. So when we bring a good systemic suit, especially one that's complicated, a federal piece of litigation, a class action, we want to make sure that we have partners to help us carry the load if we think that it is necessary for us to effectively litigate that. And so I think identifying partners is really important. We are lucky to be in a city where there are many law firms interested in doing good legal pro bono work. And we're even luckier than within that context to have great partners who we've gone back to time and time again, because folks have proven that they are kind of down with our work, down with our cause, we have a good working relationship with individual folks, and Dan has been a partner to us, not just in this litigation that we're talking about today, but we've had the pleasure to work with Dan on a number of different cases with great results, knock on wood. A key thing, and I thought folks might be commenting about this in the comments, which is pretty obvious, is making sure that we identify plaintiffs and making sure that we think hard about who we identify as plaintiffs. In some cases, we have organizational plaintiffs. In some cases, we have individual plaintiffs. In many cases, we have both. There are reasons why we want to think through the implications of who we have as plaintiffs. And I think that different organizations approach this question differently. But one thing that we all have in common is that we need to make sure that our plaintiffs understand the obligations on them to be a part of a lawsuit like this. Many of these lawsuits go on for a very long time. There can be significant burdens on individuals. Sometimes there's press and publicity around this work. And I think that talking through with your potential plaintiffs, potential clients about all of those challenges, making sure that you do due diligence into who the individuals are, the kinds of issues that might come up, the potential weaknesses, if you will, about certain facts that either individual people or organizations might bring to a lawsuit. All of that is stuff that you'd rather know up front than it is things that you want to find out through the course of litigation. And then kind of the catch-all point that I want to make is just thinking strategically, definitely at the outset of litigation, but then throughout the litigation. We've talked about some of these considerations, like thinking strategically about the partners and co-counsel, thinking strategically about the claims and the individual plaintiffs. But there are other things to take into account as well. The timing of the filing of the lawsuit, media around a lawsuit. The thing about systemic litigation, for better or worse, is that change oftentimes occurs because defendants don't like the negative attention that comes with being the object, the defendant in a lawsuit. And so you want to be strategic about this. Sometimes it makes a lot of sense to demonize and, really point the finger at a defendant to say that these things are terrible. Sometimes you want to use it strategically and say, hey, we're doing this because because we have to in order to bring you to the table, but we really think that this is something we can work out. And oftentimes it's something in between that. But being able to, in the 21st century, think about using media around the filing of a lawsuit and around different decision points and action points of a lawsuit can be really important. And then finally, not in an exhaustive list, but in an example list, thinking about what else you do other than the filing of a complaint. Oftentimes, a lawsuit will lend itself to the filing of a preliminary injunction at the same time, a motion for class certification at the same time, seeking a temporary restraining order at the same time. So just kind of thinking not only about suing someone and the claims, but also about whether or not there could be a companion filing or request at the same time that we file that lawsuit. I am going to turn it over to Dan now that I've talked in generalities about considerations to talk a little bit more about this lawsuit. I want to point out that I, despite my efforts, was not terribly successful at trying to get you guys to participate through the chat box. But again, if any of the things I've said or the things that Jennifer has said prompts you to want to ask questions or follow up in any way, please do type into the chat box. Dan?
Thanks, Chen. Why don't I start with Jennifer's suggestion that I talk a little bit about coming up with the theory of the case and how the whole thing evolved. As I mentioned at the beginning, I've had a long-standing relationship with legal aid and have worked on other systemic litigation with legal aid. And so when I saw the proposed rule that came out in December of 2018, which essentially said that the proposal was to cut around 700,000 people off of food stamps, I reached out to Jennifer and Chen and Eric. I frankly found the policy offensive. And the question was, as Chen said, was there something more than that? Was there really a legal theory there? Or was this something that just needed to be addressed through other types of advocacy work? Any of you who've studied administrative law or worked a little bit on it know that there's a process of developing a regulation in which there's a proposed rule and a comment period and then a final rule. And you can't litigate until the final rule comes out. So to a certain extent, you don't really know what your target is at the beginning of when you're looking at something like this. And the best way to at least take an initial step toward potentially setting up litigation is to participate in the comment process so that the issues are teed up in the proper way. And there's a whole strategy involved with that. As I wasn't surprised to learn legal aid was already planning on submitting comments as it always does on a significant issue of public benefits like this. And so I worked a little bit with Jennifer in particular at the comment phase. But at that point, at least from 10,000 feet, it looked possible that it was going to be an uphill climb, that this was simply a change in policy. It's very well established that elections have consequences and new administrations bring in new policies that are different than the old, and that doesn't give someone a legal claim. So we really had to wait for the final rule. Now the final rule came out on this past December 5th, and it was scheduled to go into effect on the 1st of April, which meant that if we were going to get relief to enjoin the rule, we were going to have to file a motion for preliminary injunction. In the district court in DC, there's no way you would get a judge to rule in that sort of 4-month time frame without a motion for preliminary injunction. So the first thing we worked on very closely with legal aid was the question whether there was anything arbitrary and capricious about the agency's analysis. Had it failed to consider important problems? Was its logic in the way it described the final rule just irrational or unsupportable? And the type of teamwork that we had was very important because in my focus of my legal practice at my law firm is Administrative Procedure Act litigation, and in many contexts against many agencies, looking at this sort of legal claim. But when I first got involved in this at the beginning of the comment period, I didn't know anything more about ABODs than any of you did before you tuned in today. And as Eric mentioned, Jennifer is a nationally known expert in the area, and other Chin as well, and others at Legal Aid. And so it was very important to work together on this to try to come up with a theory. In addition to that, we knew we had to file quickly, as I indicated. We knew we were going to have to file sometime in January. And there's something about the press of a deadline that can make you get creative with legal theories. And it was one of those sort of light bulb moments at some point shortly after the rule came out that I thought of a new theory about why the agency had no statutory authority to do what it did, and we ran that out. The essence of the arbitrary and capricious argument was that the new rule determines ABOD job opportunities according to general unemployment rates that are only that define the unemployment opportunities of everybody, and that it's well established for reasons such as those that Jennifer mentioned, that ABODs have a lot more difficulty getting a job than other people, such that unemployment rates are really not a fair yardstick for their job opportunities. The existing rule had allowed the agency to consider unemployment rates in making these job sufficiency decisions, but also allowed a whole array of other types of evidence to be provided by a state if unemployment rates really didn't tell the full story. For example, were there academic studies that showed that a particular area had challenges? Was there something about the relationship between populations and job opportunities that was particularly enlightening there? And we really developed, I think, a very strong argument that the use of only relying on unemployment rates was arbitrary and capricious because it did not meet the intended goal of the statute, which is to determine what the job opportunities actually are. At the same time, I thought it was important and sort of enlightening that that argument refuted a sort of a general theme that was motivating the rule, which was the general theme that if you're able-bodied, you shouldn't sit around getting public benefits, you ought to go out there and get a job. And, you know, I think that's not a principle that most people would disagree with on the face of it. The problem was that as we looked at it more carefully, the evaluation of whether there really were job opportunities was being unfairly constricted, so that ABODs were being held to too high a bar, and in reality, what the rule was doing was undercutting the fair ability to prove that job opportunities simply weren't there. Another example of what the rule did that we focused in on was the way the areas that are subject to a waiver were identified. And in DC in particular, the way the rule works, the job opportunities are evaluated in a multi-state area, even though there's supposed to be job opportunities for people living in the district. And the agency had sort of preposterous rationales suggesting, for example, that people in DC could commute to West Virginia for a job. And ABODs in particular often have difficulties with transportation issues. So we worked very hard on all of this. Legal aid took an important role in addition on the substance to working on the substance of the regulatory issues, to working with our plaintiffs to get the evidence that we needed to prove irreparable harm, which is one of the things that you have to prove to get a preliminary injunction. We put it all together. We filed the case. We had a hearing in March, and I'm delighted to report that the court issued a preliminary injunction in the middle of March, stopping the implementation of the rule. And as we now sit here today, we're working on the briefing on the merits, which is summary judgment briefing, which will continue on for the next month or so.
Great.
So
Oh, yeah.
I see the slide says how do law firms staff these cases. Should I move on to that, or? Okay.
Yeah, I think it would be helpful to just, because we have a lot of summer associates on the call, on the webinar, who might be interested in, you know, how junior associates can get connected with these cases, how you think about, you know, who's going to do what on these cases, that might be interesting.
Sure. Well, let me first say that one of the things that's very helpful in getting involved in any pro bono case, I think at a junior level, is to see whether you can put together a fairly big team, because one of the things that associates find is sometimes they're not really in control of their own schedules. They think they have time to work on something, but they get surprised by a partner who changes that all very quickly. And so that if two or more associates can work on the same pro bono case, there's a lot more flexibility to fill in for each other and pinch hit, get the job done when unexpected things happen. And so in this case, we had a team of 6 lawyers at Alston & Bird, which is, I think, probably a larger team than we would have had for a paying client, for the reason I just mentioned. We've had 2 partners and 4 associates working on it, including associates in different offices. How did I choose the associates to help on this? Well, I wanted to make sure that I found people that were really committed, that would be that I could rely on in a tight time frame to get the job done. Because in a preliminary injunction litigation, you really don't have time for people to drop the ball. You're really giving people a lot of responsibility and relying on them to do what they're supposed to be doing. We happen to be lucky that we have a firm-wide director of pro bono who's very dialed in with the various associates in our different offices about who has been expressing a lot of enthusiasm about working on pro bono cases. And so she had sort of a short list for me of people to think about. And what I asked her to do to figure out who was really committed was to point out that it was December and the injunction was being filed in January, and how many people were okay working on it between Christmas and New Year's. And I found out that only some people were willing to do that. And those were the people who made the cut. Those are the people who were willing to give up some vacation time to really achieve an impressive result. I think that another thing that helps with staffing is to make sure that there's sort of a spectrum of people of different levels of seniority, so that you know, different tasks can be done by different people. And I guess that's really how we staffed it here. There's no particular model because these things are, by their very nature, not routine and don't really have a sort of a one-size-fits-all approach.
Great. And then going to the next slide, Jen and I have both talked about, Dan, your extraordinary commitment to pro bono. So we thought it might be helpful for people to hear about your personal journey for, what it's worth, for to use a slightly touchy-feely phrase, and just like on a practical level, like you're obviously a busy person and you have a day job. Like how do you balance pro bono and maybe thinking about like when you were a lot earlier in your career, how you sort of balanced doing pro bono and the commitment to pro bono with your work for paying clients?
Right. Okay. Well, first of all, let me say that as a more junior person, there were long periods of time when I simply couldn't fit it in. It just wasn't realistic because the demands were too great. But nobody's, super busy forever, and there are always peaks and valleys. And so one of the approaches I took was, as soon as it looked like I would have a little bit of extra time on my hands, I would reach out and I would try to work on a smaller matter. Legal Aid has a wonderful referral of lists of pro bono opportunities, as do other organizations. There's no shortage of opportunities about getting involved. But that's one of the things. You sort of have to take the long view and realize that this is going to be a part of what you're doing, not all of what you're doing. The other thing that's important, I think, is to recognize that a lot of lawyers have a lot of reticence to be doing something in an area that they don't really know or something that they haven't done before. And most of the practice areas where legal aid represents people are different than the practice areas in a private law firm. And so, people who want to be sure they're doing first-rate work, understandably, might be a little bit reluctant to get involved. It's true on the partner level too. As the more senior you get, the more reluctant you are, I think, to acknowledge that you don't know something. So training is critical. And for example, in the public benefits area, for years, Jennifer has done trainings for people. There are materials to work with. It's not like you're just sort of cast adrift to work in some new area that you don't know. There really is a lot of support, and there's ability to get back in touch with the referral organization like Legal Aid when you have questions and need more guidance. I think as a junior person and as a senior person, being really well organized is important. I know that I discussed a briefing schedule with Jennifer and Chin in this case a couple of weeks ago to make sure that it was okay with them to fit it in with a way that would be workable for me. I think it's harder to do this if you're sort of a last minute procrastinator, but easier to do it if you sort of try to orchestrate it in advance, and then you know when you're going to be available and when you're not. Now, as an associate, you don't have the same kind of control, but you can do planning ahead in the sense of notifying partners. I have this pro bono hearing coming up on the 1st of June. I want you to know that and see if there are going to be any conflicts, so that you're not placed in a position of surprising a partner with an obligation that person wasn't aware of. And at the same time, if you're working on a bigger team, as I mentioned at the beginning, if it's not a reconcilable conflict, then you have someone else who could fill in. I think the final thing I would say is it does require a lot of hard work. I think that if you do this kind of work, you will work harder than you would if you weren't. And there's something very rewarding about that. It's been certainly a great highlight of my career. But I think it's, you know, it's like the people I wondered whether they would work between Christmas and New Year's. There just comes a time when if you're going to do this kind of work, there's no way around it. You're going to have to put in some extra hours, but I would say it's well worth it.
Chen, you're muted.
Oh, sorry about that. I know you didn't ask me, Jennifer, but I was just going to supplement a little bit of what Dan is saying and see if Dan agrees with my perspective. I was once a law firm associate as well, and that experience, plus frankly my experience as a parent, has informed a little bit of my view about time management as well. And that is, I think some of us take the view that things like pro bono or sometimes family obligations have to fit into the cracks of the other work that we have. And so, hey, this week I have a couple of extra hours, find me some kind of pro bono nibble that I can do in the 3 hours I have this week. But next week, when things pick up, I'm going to have to kick that to the back burner again. And I think that's one way to approach it. But I think if you want to have a successful long-term involvement with pro bono work, I think you have to make it and frankly, in terms of my experience with my family too, you kind of have to make it a priority as with everything else. Now, you can't make it an outsized priority, right? Because at the end of the day, it's not like your firm is going to pay you to do 1,000 hours of pro bono for the next 10 years. But I think that making a commitment and finding a way to mark that off and allow for that commitment to take precedent over other things when there is a conflict in the margins is also important. So if you have a hearing a month down the line, you want to put that on your calendar and, you know, prepare for, and as Dan said, not procrastinate about the preparation that needs to be done to get you there. And if other stuff comes up, it might mean that for a short period of time, you have to work on overdrive a little bit. But I think if you're going to only work on it when you have that small amount of time, just like if I don't set aside a long weekend for me to take vacation, but only look for the time when I happen to have a Friday off, that Friday off is going to come way too infrequently, and I'm going to regret the 3 years went by and I never took that long weekend with my family. So I do think that it does require some intentional prioritization of those commitments in our lives as well.
Absolutely, I think that's right, and frankly, if you're only going to do an hour or two when it's convenient, there's not a lot you can do. There's some very, very simple routine things that you could do, but if you're going to work on something that's sort of complex and interesting, it's certainly something as complex as interesting as enjoining a federal regulation that would cut 700,000 people off of food assistance. It's just going to take more time, and you're going to have to be committed to that.
And I think I have not been at a firm, but I've worked with a lot of pro bono attorneys, and I think the people who have the best experiences, at least as far as I can tell, are people who are, you know, who are committed to the clients they're working with, who are able to, you know, able to understand and imagine all the conflicting things that are going on in our clients' lives. And, you know, as Dan said, are like both willing to take a risk of doing something that they haven't done before, yet also having the humility to be able to acknowledge that they need some support and help. And we've certainly worked with lots of associates and partners on these types of cases, but most of the pro bono attorneys I've worked with have been on individual cases. And then we'll leave a few minutes for questions in case people have thought of any, but just to finish up, I want the picture that you're seeing is us, me, Dan, and Chin, and then between me and Chin is our legal aid colleague, Nicole Dooley, who did amazing work working with our clients and getting their stories out, and in a way that really supported the legal theory. Next to Dan is one of his colleagues from Alston and Bird. I can't remember which one it is. And then between me and Dan is one of our named plaintiffs, Geneva Tan. Ms. Tan is someone who would be affected by this rule if it were to go into effect. She has a work history. She has had jobs in the past, and has, gotten jobs and then lost those jobs, and is not employed at the moment, and has had domestic violence and interactions with the law in her past, all of which make it hard for her to maintain employment. And so she's been a tremendous partner in working with us and helping us bring this action on her behalf and all the hundreds of thousands of people who will be affected by this rule. And then Chin also points out that we should acknowledge Rebecca Lee, who is now at WilmerHale, and who volunteered with legal aid for a couple of months between her clerkship and starting with a law firm. And she put in, this was her job, 24/7 she was spending tracking down potential plaintiffs and interviewing them and scheduling appointments and rescheduling appointments, and just did a tremendous amount of work to help us get ready. So these cases definitely take a village, and we had one in this case. So I think we have a couple minutes left, but does anyone have any questions about or comments about anything that we've talked about? You can put in the chat box, raise your hand, or some other way of making yourself known. So it looks like we have a question from Kurt. Do you anticipate having any case involving persons that may have problems obtaining a job as a result of their involvement with the protests? So Kurt, I don't know if you want to unmute yourself, but are you talking about people who may be arrested because they're protesting, or because of what is your question about? Oh, no audio. Yes, arrested or other problems. Yeah, I mean, it's a really good question. We're certainly, and of course it does provide, whatever's going on now provides this huge backdrop to what we're talking about with this rule. Like, at the time that Dan argued this case, we were still in an economic boom, and since the PI order was issued, we're now in a recession/depression, which makes there fewer jobs available. Although ironically, the math seems to suggest that DC still wouldn't qualify for a waiver under the current rule. So for people who have been participating in the protests and who are arrested, we do actually have a project at Legal Aid that deals with record sealing for people with criminal histories. And so potentially that could be something that we would look at. Chin, is this, do you have any thoughts on the question?
Yeah, and DC also has a relatively progressive ban the box law for employment about the kinds of inquiries that employers in DC can make about your criminal record or criminal background. So I think there may be opportunities to be involved in this kind of work. I've actually seen a number of emails on listservs about this potential issue. I can't say from our vantage point, I think Jennifer's or mine, that we have seen a case like this come in, but certainly there may be opportunities for involvement if they do come in.
Thank you. It's a great question. Any other questions? I guess the other thing I have also just read in the paper is that it sounds like the Office of the Attorney General is not being terribly aggressive in prosecuting people for who were arrested during the protests. So that might also mitigate some of the harm. All right. Well, question from Victoria. Are there opportunities for law firm staff, non-attorneys, to support this work? Dan, do you want to talk about that?
Absolutely. We have, and I should have mentioned, in addition to our two partners and 4 associates, we've had a couple of paralegals assisting us with putting the briefing together. Obviously, the clerical help is necessary getting the job done. And actually, in this latest round, we've had our e-discovery team helping us put together a database that would allow us to search the record materials more efficiently. And we found that you know, all of the different staff people we've worked with have been incredibly enthusiastic about it. I mean, the e-discovery staff was thrilled to be asked, frankly, because in their day-to-day, they never really realized that they would have the opportunity to work on something like this.
Yeah, and I mean, again, in my experience, I haven't worked with a lot of non-attorneys in pro bono work, but I know that they have supported that work. You know, I've mentored a lot of cases on Social Security disability hearings, and the paralegals and non-lawyers have been the ones involved in collecting the records and working with the clients, and have definitely supported those cases. All right, I think we have time for one last question, if anyone has one. All right, well, if you do wake up at 2:30 in the morning and have a burning question about our work or this case or anything else, you can find us all on our respective websites. And thank you very much for participating. Thank you for supporting Legal Aid, and have a great week and stay safe and healthy.